Welcome everyone, and happy Monday. My name is Aaron England. I am the chair of the Bench and Bar Committee for the Northern District of Georgia Bankruptcy Court. This is the 12th installment of the Bench and Bar Committee's Lunch and Learn program. As a reminder, this session, once it's done, and all previous sessions will be available on ganb.uscourts.gov/bench and bar committee. That will include all the past and present presentation materials and past and present videos. If there are any questions during the presentation, please feel free to put those into the Q&A box in the Zoom session, and the panelists will take those up either during the discussion sessions or at the end. There we go, just a couple of disclaimers before we get started. The following scenarios are fictional. They do not depict any actual person or event. All of the players are acting their parts. These are real lawyers and a real judge, but everyone is performing for demonstrative purposes. And Judge Cavender's rulings on evidentiary issues do not indicate how he might rule on an actual matter presented to him. Our cast of characters today going to be panelist Judge Cavender. He will be played by Judge Cavender. Creditor counsel will be played by Brian Bates with Parker Hudson, Rainier and Dobbs. Debtor counsel will be David Johnson of Hurt & Johnson and Ashley Champion of Polsinelli. And our witnesses, Mary Debtor, will be played by Kennedy Bodnarek of Parker Hudson, Rainier and Dobbs, and Tom Banker will be played by Matthew Weiss of the same firm. So please join me in welcoming our panelists, and thank you everyone for attending. With that, I'll turn it over to Aaron.
Thank you, Aaron. So the goal of this session, hopefully, is to give everyone, particularly young lawyers who haven't had much experience presenting evidence, examples of some of the things to do and not to do in a courtroom. We've put together 3 short scenarios of typical events that you would see in a consumer bankruptcy case: a motion to impose stay, an objection to a claim of the IRS, and a motion for relief from stay. And we'll present each of these scenarios in an effort to demonstrate how to get evidence admitted, how to object to evidence, how to make a proper proffer, among other things. And so the goal is at the end of the program, hopefully you have a better understanding of how to effectively present evidence in a virtual hearing, although many of the things we talk about would work just as well in a live hearing. So let's go to the next slide. So the first scenario is a motion to impose stay, and this happens to be Mary Debtor's 3rd Chapter 13 bankruptcy case, filed and pending within a year. So Mary's first case was dismissed after Mary failed to pay the filing fee. Her second case was dismissed for failure to file all the necessary information in her case. And in this, her 3rd case, Mary moves for imposition of the stay under Section 362C4. First American Auto Lending holds a claim against Mary's bankruptcy estate secured by Mary's 2017 Toyota Camry. First American Auto Lending opposes imposition of the stay. We join the hearing in progress. The court has heard the legal arguments of counsel and has determined that it must hear evidence to decide the matter. The witness's oath has already been administered, and we're proceeding. Mr. Johnson, call your first witness.
Mary Debtor, are you on the line? And Your Honor, did you want to check the witness's surroundings, or would you like me to?
Is Ms. Debtor on the line? I don't see her picture.
I am.
All right, Ms. Debtor. Ms. Debtor, is there a way? I only see half of your face, Ms. Debtor. Is there any way for you to change your camera so that I might be able to see your whole face?
Oh yes, I'm sorry. One moment.
Much better, Ms. Debtor. Now, Ms. Debtor, are you in a room by yourself?
I am.
And do you have any documents in front of you other than the documents that your counsel has provided in connection with this case?
No,
And do you have any access to communicate with your counsel other than via this Zoom hearing?
no. Mm-mm.
No access to email, no access to chat features? Can you answer verbally, Ms. Detter, please?
No, I do not.
All right. And have you taken any notes on the documents that have been presented by your lawyers for use in connection with this hearing?
No, and they're not near me.
Okay. And you don't have any notes with you at the present time?
I don't know.
All right. Go ahead, Mr. Johnson.
Thank you, Judge. And before I begin, I wanted to thank your law clerk for reaching out to me ahead of time and reminding me about the procedures you have for submitting exhibits and anticipated objections. I had emailed them to opposing counsel, but I had not separately docketed them initially. All right. Now, Ms. Detter, could you please state your full and correct legal name?
Yes, my name is Mary Winona Detter.
Are you the individual who filed this bankruptcy case?
I am.
As a brief background, what's your age and level of education?
I am in my late 30s and I have a high school degree. I started my associates and I didn't finish it.
Regarding employment, what has your last year of work history looked like?
I mean, it was kind of up and down. I was at Bed Bath & Beyond and that was good. I liked it. It was close to where I live. My hours were steady. And then I got laid off at Bed Bath & Beyond and I didn't know what to do for a while. And now I'm working at an Amazon warehouse. But it's not ideal.
Before we discuss the current bankruptcy case, have you filed bankruptcy before?
Yeah.
How many times?
Before this case, 2.
Regarding that first case, what led you to file it? Why did you file it?
Well, it was like what I was saying about Bed Bath & Beyond. I mean, I have this car loan, I have all my expenses, and I got laid off at Bed Bath & Beyond. I wasn't fired or anything. I lost my job and I couldn't make my payments. And so I knew that my car was going to get repossessed. So I had to file so I could keep it. So at least I could make it to my other job.
When you realized you were behind on those car payments, what actions did you take?
Well, I let the car company, First American, know that I needed to apply for their, I don't know what you call it, a delay in payment or something. Because when I bought my car, the car dealership told me that I was allowed to get some kind of abatement. That was something they offered, and then I would apply for that, and then I would be granted that. And so I applied for it, and I had to stop making some payments after I applied for it, and that's what happened.
Your Honor, if I may interject, this is Brian Bates, counsel for First American. Your Honor, I would move to strike the testimony from Ms. Detter with regard to what she was told by someone else at the car dealership on the basis that's hearsay.
Mr. Johnson, any response?
Yes, this is not hearsay. This is not a situation where that statement is being offered for the truth asserted that there was an abatement option. Mary here, she's simply explaining what actions she took and why. So we'd contend it's not hearsay.
I'm going to overrule the objection and allow the testimony.
Thank you, Your Honor.
Mary, what happened with the first 2 bankruptcy cases?
So I filed bankruptcy because my car got repossessed and I was looking online. I needed to figure something out. So I filed for bankruptcy and it looked like I could file it online alone. And so that's what I did. I filed it myself. And the first case got dismissed. I didn't know that I had to pay a filing fee. That was news to me. It didn't say that online. And then in the second case, I was paying and I was making my payments, but then it got dismissed because I didn't know I had to appear for a meeting and nobody told me.
Why didn't you hire a lawyer in the first 2 cases?
Well, like I said, when I looked online, it didn't say that I had to. I figured it was something I could do on my own, and lawyers are expensive.
That's a fair point. What made you hire a lawyer this time?
Well, when I met with you guys, I really liked Miss Champion, but that's
Was there anyone else who you, never mind. Turning to the car, regarding the 2017 Camry, what do you intend to do with the car and the car loan in the current bankruptcy case?
well, I'd like to keep the car. I want to make the payments. I need the car to get to work. You can't really make payments if you don't have a job, and you can't get to your job without a car.
Your Honor, do I have permission to display Debtor's Exhibit 1 on the virtual courtroom screen?
You do.
Mary, can you see this okay?
I can see it.
Let me quick scroll for a second. Do you recognize this?
Mhm.
Is that a yes?
Is that?
Yes.
What is it?
This is something we filed in my bankruptcy case. This is how I'm going to pay everybody back.
And did you sign this document?
Yeah, I think it was electronic though.
Does this appear to be a true and correct copy of the document you signed?
It does, yeah.
Your Honor, I move for admittance of Debtors 1, the Chapter 13 plan.
Any objection, Mr. Bates?
Your Honor, I don't really have an objection to what appears to be the primary document at issue here, but I see more on the screen than just the document they're discussing. I see items on the side of the screen, and I would object to the admission of that information in the record.
When you say on the side of the screen, what are you referring to? I see an easy Zumba workout and amazing Amazon pay stubs. Is that what you're talking about?
Let me fix that, Your Honor. Sorry about that. Does that cure your objection?
Does that resolve your objection, Mr. Bates?
Those items going away do resolve my objection. I had on the other side of the document, it looks like there's just a host of information below Adobe Export PDF. I'm just not sure if that's intended to be introduced as evidence as well.
No, Your Honor, only the PDF is intended to be admitted. And again, that's
Right,
on
so
the
if
court docket.
If we restrict the admission to only the PDF Chapter 13 plan, Mr. Bates, does that solve your issue?
Yes, Your Honor.
All right, the Chapter 13 plan as PDF, what's the docket number, Mr. Johnson?
I believe it's at number 5.
Will be number 5 will be admitted without objection.
Okay, Mary, if you can follow me to page 2 of the plan. Under section 2.1, what's the overall Chapter 13 payment you're proposing to make?
It's $400 a month to the Chapter 13 trustee.
And turning to page 3, under section 3.2, what are you proposing to do with the First American Auto on the 2017 Camry?
I'm proposing to pay it off. I want to keep the car, pay it off for the value that it is, and get my discharge.
And one more time, why is it important for you to keep this vehicle?
Well, I can't pay anybody back if I don't have a car to get to work. You got to have a car to make money.
Your Honor, I will stop share briefly. Okay, and Mary, how much have you paid to the Chapter 13 trustee so far? Do you know?
Well, I just filed my case really recently, so I've made one payment. I think I have
And-
one coming up too, but I've just made one.
How are those payments being made?
I think I send a check to the trustee's office.
Do they come from you directly or from some other source?
They come from me. I pay for them.
Your Honor, if I may display debtors 2 on the screen.
You may.
Mary, do you recognize this?
Yes, I do.
And what is it?
This is my pay stub that I get from working at the Amazon warehouse.
Does this look like a true and correct copy of your last pay stub?
Yeah, it does.
Your Honor, I move for admittance of debtors 2.
Any objection, Mr. Bates?
With the
Just the
caveat
PDF.
that the information on the side of the screen is not included in the exhibit, no objection, Your Honor.
All right. Debtors Exhibit 2, as it appears on the docket of the case, will be admitted without objection.
Now, Mary, under the category other, how much has been paid out for the bankruptcy so far?
So far 300.
Now, does this refresh your memory about how the payments are being made, whether from you or your employer?
Yeah, I totally forgot. We set up the thing where it's taken out of my paycheck and I'm not sending them a check. That's just getting taken out. I forgot.
And finally, can you continue to afford to make these payments?
If I keep my car, yes, absolutely.
Your Honor, nothing further for now. I'll reserve potential redirect.
All right. Cross-examination, Mr. Bates?
Yes, Your Honor. May I proceed?
You may.
Good afternoon, Ms. Detter. My name is Brian Bates. I'm counsel for First American Auto Lending. I have just a few questions. Your Honor, requesting permission to present a document to the witness.
Yeah, you may.
I'm pulling it up now. Ms. Detter, can you see the document that I put on the screen?
Yes,
Please answer verbally, Ms. Detter. Is that a yes?
yes.
Ms. Detter, I would submit to you that this is an email exchange between you and a representative of my client from earlier this year in January of 2023. Do you recognize these emails?
Objection, Your Honor.
What's your objection?
Mr. Bates is narrating what's in the document, but more importantly, this is the first time I've seen this. This was not on the exhibits and exchanges put on the court docket and exchanged prior to the hearing. I'd also contend it's hearsay, looking at for the first time at what this may be.
Mr. Bates, response?
Your Honor, this document is being presented for impeachment purposes. Ms. Detter testified earlier with regard to the abatement process, and this is being offered to refresh her recollection with respect to what actually happened.
How long have you known about this document, Mr. Bates?
Well, Your Honor, it's been in my client's files from the beginning. We certainly did not expect her to be testifying that in the way she did with respect to the abatement. So we didn't put it on the exhibit list because we never thought it was going to be relevant. However, as soon as I heard her testify with respect to the abatement process, I pulled this document up, and I would submit that it's appropriate to use a document like this solely for purposes of impeachment in this instance.
Do my courtroom procedures deal with impeachment evidence or provide any exclusion for requirements to produce documents in advance that are going to be used for impeachment purposes, Mr. Bates?
Your Honor, I don't believe it provides a specific exception for impeachment. I don't believe that it specifically provides anything about impeachment evidence. And so in this instance, and given just the fairness and having an accurate record, even though there's not an express prohibition or permission to do this, we would submit that it's appropriate to show the witness this information in order to clarify the record here.
Mr. Johnson, any further response?
No further response. I would simply reiterate what I did at first with the objection.
All right, I'm going to overrule the objection and allow the questioning.
Thank
Thank
you,
you.
Your Honor. I'll be brief and I'll stick to the purposes of what I just intended. Ms. Detter, can I direct your attention in this email exchange here to the email that is dated January 22nd? Can you see my, January 2nd of 2023? Can you see my cursor as I reflect this document here?
I can see it.
Okay, as I scroll down, would you agree with me that this is an email communication from a representative of First American to you dated January 2nd, 2023?
Yes.
And would you agree with me that in this communication, while the representative advises that she appreciates your communication, is very sorry to hear about the challenges you're facing with respect to paying your car loan, that the payments are due in the first of every month, and if you believe you qualify for a formal abatement, then she gave you a link for you to apply for such abatement. Do you see that? Do you agree with that?
Yeah, I'm confused though, because if you scroll down, I thought my email was that application.
Understood, Ms. Detter. But if you see, if you responded to her email later that same day, you said, "Thanks so much for understanding, such a relief. I'll stay in touch with you and we'll pay the loan the best you can." But would you not agree that the next day, January 3rd, that same representative confirmed the receipt of your message, but gave you that same link in order to apply for abatements? Would you agree with that?
Yeah, I guess, yeah.
So with your recollection refreshed, do you think you ever actually applied for an abatement of any payment obligations?
I guess I didn't.
Thank you, Ms. Detter. One further inquiry. Your Honor, I'll stop sharing this document. Your Honor, I would request permission to show the witness another document which has been marked as Exhibit 13-4, filed in the docket and shared with opposing counsel, so we shouldn't have the issues that we faced with the prior impeachment evidence.
All right, permission granted.
Ms. Detter, do you see this document's been marked and filed at 13-4?
I see it.
Ms. Detter, did you wreck your car on May 17 of this year?
I mean,
Objection.
I got into,
Wait 1 second, Ms. Detter. Mr. Johnson, you have an objection?
Yes, I do. This has not been admitted yet, as noted in the exchanges ahead of time. We're also objecting due to lack of authentication and relevance. This is a post-petition article, and that's not relevant for her good faith or lack thereof in filing the third bankruptcy case within a year.
Mr. Bates, response?
Your Honor, first and foremost, with respect to authenticity, this document was shared with opposing counsel ahead of time as indicated and pursuant to your rules. Any objections to authenticity need to be filed and submitted within 2 days prior to the hearing. We received no such objection an issue with respect to authenticity. But furthermore, Your Honor, putting that aside, a newspaper article such as this, which has all indications of being genuine, is self-authenticating, and therefore there is no basis for authentication objection. With respect
What
to
about
the
his relevance? What about his relevance objection, Mr. Bates?
Certainly, Your Honor. Which, yes, this the date of this article is post-petition, and so if Mr. Johnson's objection is that it could not possibly be relevant to whether or not this case was filed in good faith, Your Honor, we would submit that it is absolutely relevant to the catch-all provision with respect to if there's any other reason to have any concern about whether or not a Chapter 13 plan can be confirmed and performed. And that's indeed the legal standard here. And so the fact that this car has been wrecked be reflected by this article and by Ms. Detter's testimony with respect to same would be relevant to these proceedings.
Mr. Bates, certainly it might be relevant to confirmation of a plan, but is it really relevant to whether the stay should be imposed in the first instance?
Well, just with respect to the catch-all provision, Your Honor, with respect to imposition of the stay, we look to whether or not a plan, is reasonably anticipated to be confirmed. And here, I think it's relevant that the collateral here is damaged.
All right, I'm gonna overrule the objection on authenticity grounds. Newspapers, as Mr. Bates points out, are self-authenticating. I'm going to sustain the objection on relevance grounds and disallow the emission of the exhibit at this point in time.
Thank you, Your Honor. Ms. Detter, you did indeed wreck your car into the mayor earlier this year, did you not?
I would call it a fender bender because I can still drive my car and he can still drive his.
Okay, thank you. Nothing further, Your Honor.
All right.
No redirect.
That concludes, no redirect. That concludes the evidence presentation on the first segment of the program. We thought we would talk briefly about each segment before we move on to the next one. And I'll begin by making a couple of points. One is you need to be prepared to present documents. If you're particularly on a virtual hearing, you need to be prepared to present documents on screen. And you need to make sure you know how to do it. If you don't know how to do it, you need to learn how to do it. Or you need to have somebody working with you who knows how to do it. And you need to be able to do it effectively and quickly so that you're not wasting the party's time, the court's time, everyone's time. As demonstrated here, you need to make sure you're careful as to what is shown on your screen in addition to the document. You would be surprised at how often people share their screen and show things beyond which they probably would prefer not to share. And so that's an important takeaway. Number two, you need to make sure you know the judge you're appearing in front of's rules with respect to documents, when they need to be produced, how they need to be produced, whether they need to be produced in advance of any evidentiary hearing. And you also need to be cognizant of your particular judge's rules with respect to witnesses. I have particular rules which say a witness has to be in a room by themselves with no documents in front of them other than the documents that have been marked in advance of the hearing. And I've had issues with documents in hearings, in a virtual hearing, where witnesses wrote notes in the margins of their exhibits, which presented a problem. And we had to stop the hearing to have the notes produced. And so usually when I have a witness take a stand in a virtual hearing, I'll go through the same litany that I went through with this witness to make sure that we're all on the same page. The witnesses by themselves has no ability to communicate with their lawyer. And has not made notes or doesn't have notes in front of them. So those are things that you need to be prepared for, and you need to make sure you test your witnesses' Zoom view before the hearing so that when the hearing starts, their face is not cut off in half or other inappropriate things are in their background. Those are important lessons. I'll turn it over to Mr. Bates. Any additional comments from you?
Thank you, Your Honor. Yes, I mean, just following on the notion of understanding the rules in the court rules with respect to the marking of exhibits and exchanging exhibits. And so we just wanted to flesh out, some potential mistakes or issues that would arise. And with respect to the impeachment issue, it's not completely clear as to how that would proceed in a real courtroom setting. But we just kind of wanted to flesh those items out and give a little demonstration of it.
I'll add a comment. I've often thought that I need to amend my rules to specifically deal with the possibility of impeachment or rebuttal evidence that's not shared in advance. I've not done that, but maybe I should. Mr. Johnson, anything from your perspective?
No, the one part I'll highlight, like you said, is knowing the technology. I think that's really important. Now that we're doing it with a lot of things virtually, there's this added layer of chance for a problem or a mistake or showing something you don't want to.
I would also say that I thought both lawyers did a good job of answering questions in the appropriate form. Mr. Johnson's questions were direct questions, not leading the witness, allowing the witness to tell her story, whereas Mr. Bates' questions were leading questions. that required a yes or no answer for the most part, and weren't open-ended, allowing the witness to say whatever she wanted. She had to answer the question that he asked. And so I thought Mr. Bates did a good job of using leading questions, which frequently is not what I see from lawyers on cross-examination. They frequently ask open-ended, non-leading questions on cross-examination, and you should not do that. With that, I think we'll move to the second hypo, if we can put that on the screen. So the second one is an objection to an IRS claim. Later, after Mary's motion to impose stay is fully resolved, Mary objects to the claim of the Internal Revenue Service. The attachment to the IRS's claim shows taxes for several years, including estimated for 2022. And after filing her third bankruptcy case, Mary asserts that she has submitted the 22 tax return for the estimated year and seeks to reduce the IRS's claim to the amount she owes. And despite adequate notice and service of the objection, the IRS has not amended its claim, filed a response, or communicated with Mary or her counsel in response to the objection. The calendar's been called and Judge Cavender has taken the bench to hear Mary's objection. Mr. Johnson, you may proceed.
Thank you and good morning, Your Honor. David Johnson for the debtor. This is an objection to claim filed by the IRS showing in part unfiled 2022 return with estimated taxes estimated at $2,060. As the pleading states, she has filed that return a couple months ago, showing only $460 are owed for 2022. We're asking that the claim be reduced accordingly. At the call of the calendar, the clerk marked the matter to be heard, which normally for me indicates there's a service problem. I went and reviewed the service papers on the objection, and it appears to be proper for serving a federal agency under Rule 7004, and no responses were filed by the IRS.
Mr. Johnson, I appreciate your recitation and your confirming proper service. The problem is under Federal Rule of Bankruptcy Procedure 7055, which incorporates Federal Rule of Civil Procedure 55, and specifically Rule 55D, a default judgment may be entered against the United States, its officers, or its agencies only if the claimant establishes a claim or right to relief by evidence that satisfies the court. Here we have no evidence, no tax returns have been admitted into the evidence. There's no tax return attached to your objection. I appreciate the statements in your objection, but that the tax return has been filed, but there's no evidence in front of me upon which I can render a default judgment against the United States. And so I'm going to have to deny your claim in its current posture.
Okay, thank you, Your Honor. I've taken some notes down about that. If I may have leave to file an amended objection, and we'll be more prepared next time.
Yes, so your objection is going to be denied, and you are free to file an amended objection. For purposes of this hearing, we're now 30 days later, the objection has been refiled, and we're back before the court on the same objection to claim. Go ahead, Mr. Johnson.
Good morning, Your Honor. David Johnson for the debtor. This is an amended and resubmitted objection to claim of the IRS. I have my client, Mary Debtor. She should be in or joining the virtual courtroom. Mary, can you hear me?
Debtor, are you there?
Hello?
Hi, Mary. Can you
Are you there?
activate your screen?
Oh, yes.
Very good. Your Honor, may I make a proffer to the court?
You may.
If the debtor were sworn in, she would testify to the following: that she is the debtor in this Chapter 13 bankruptcy case, that she completed a federal 2022 tax return. And if I may pull up the exhibit attached to the amended objection.
You may.
Mary, can you see that?
Yes.
She would, thank you. She would also testify that this is a true and correct copy of the federal tax return that she submitted to the IRS for tax year 2022, And finally, she would testify that it was properly filed and accepted by the IRS. That's it for the proffer, Your Honor. And finally, I would also again point out that no responses or objections were raised by the IRS and no one else appeared at the hearing.
Right. Any party in opposition to the objection to claim? There being no opposition, the court accepts the proffer counsel has made on the record and will sustain the objection to the IRS claim based on that proffer. That concludes the evidentiary portion of this session, and we'll have a brief discussion of this session as well. Mr. Johnson, any thoughts from your perspective?
Well, an important one is to know the rules, especially for young lawyers. There's lots of small traps out there in the bankruptcy code and the bankruptcy rules. I know, in law school, we didn't spend much time on the bankruptcy rules, and they can be very important. So make sure you read and understand them. And then I think too, sometimes mistakes happen. I've certainly made plenty, and it's okay. You can normally go and fix it. Like we could here. So don't be too upset about it, and get it right the second time for sure.
I agree with everything Mr. Johnson has said. This is not an uncommon occurrence, particularly as it relates to objections to claim of U.S. government entities. And we frequently have to deny the objection because the witness is not available to do a proffer. And some judges might allow a proffer absent the debtor being present. I generally do not. And so, again, you need to know what your judge's practices are. I would generally require that the witness be available and on the screen or on the phone at least before I would accept a proffer of evidence from that witness. And that's really the only additional part that I would add to this session. So why don't we go to session number 3. And this one is a motion for relief from stay. We're later in the case. We've had the stay imposed. We've had the IRS objection sustained, and the IRS's claim reduced. And now First American Auto Lending is seeking relief from the stay to repossess and dispose of its collateral. Mary Debtor has not yet confirmed her Chapter 13 plan over the objections of the Chapter 13 trustee and First American Auto Lending. We joined this specially set evidentiary hearing after the calendar call and after opening statements. All witnesses have previously been sworn. And Mr. Bates is counsel for the movement now. Mr. Bates, you may begin.
Thank you, Your Honor. Good afternoon. Brian Bates for First American Auto Lending. We're here today, Your Honor, on a motion for relief from stay with respect to an automobile loan by my client, First American, to the debtor. With me today, Your Honor, is Mr. Tom Banker. He is on screen, who's representative of the lender. I expect to call Mr. Banker to testify, as well as I expect to call the debtor on cross-examination as well. Your Honor, in accordance with the rules on your judicial webpage, we've exchanged all exhibits that will be used today with Ms. Debtor's counsel 7 days prior to the hearing. We've uploaded our exhibits to the docket. So I'm requesting, Your Honor, permission to call my first witness.
Permission granted, and for the viewers at home, I've already gone through the same questions I would have asked Mary Debtor with respect to Tom Banker, with respect to being alone and by himself and with only the documents in front of him. So go ahead, Mr. Bates.
Thank you, Your Honor. Calling Tom Banker. Mr. Banker, can you state your full name for the record?
My name is Tom Banker.
And you work for First American Auto Lending, correct?
That is correct.
You're the credit manager there?
That is correct.
Objection, Your Honor. He's leading the witness.
Response, Mr. Bates?
Your Honor, strictly for introductory purposes, I acknowledge I was being a bit leading there, but I think that's permissible and purely introductory matters.
I'm going to overrule the objection, but don't get carried away with it, Mr. Bates.
Understood, Your Honor. Thank you. Mr. Banker, what are your job responsibilities generally?
Well, as the credit manager, I'm responsible for overseeing the loan portfolio for First American.
Your Honor, requesting permission to show the witness the document filed and marked as Exhibit 13-1.
Permission granted.
Banker, I'm pulling up on the screen a document that has been marked as Exhibit 13-1. Do you see that document on your screen?
Yes, I do.
Do you recognize it?
Yes, that appears to be the loan agreement and note the bank has with Mrs. Detter.
What is the date of that loan agreement?
I believe it's March of 2020.
And who are the parties to the loan agreement?
Mary Detter and First American Auto Lending.
What does this provide that Ms. Detter's monthly payment obligations are to the bank?
$400.
Objection, Your Honor. He hasn't properly laid the foundation for this document. At this point, it's impermissible hearsay, and he hasn't established that Mr. Banker has any personal knowledge as to this document.
Mr. Bates, response?
My apologies, Your Honor. May I be allowed, I got a little carried away, may I be allowed to back up and lay a proper foundation for this document?
Yes, objection sustained, but please proceed.
Mr. Baker, backing up just a moment, how are you familiar with this document?
Well, as the credit manager, I'm responsible for knowing about the loans that we make and including their terms and documents.
Is it customary that the bank would make a record of its entry into a loan agreement like this at or near the time of entry into such agreement?
Yes, it is.
Who at the bank would be responsible for making a record of entering into a loan like this?
It would be the loan officer that was responsible for that particular loan.
And are documents of this nature kept in the ordinary course of the bank's regularly conducted activity?
Yes.
Is making a record of a loan agreement such as this a regular practice of the bank?
Yes, it is.
And you're familiar with those practices of the bank?
Yes, I am.
Your Honor, I would now move for Exhibit 13-1 to be admitted into evidence.
Ms. Champion, any objection?
No, Your Honor, not without foundation.
All right. Exhibit 13-1 will be admitted without objection.
So back to where we were talking earlier, Mr. Banker, what are Ms. Detter's monthly payments owing?
I believe she owes, you mean the total amount owed?
Her monthly payment obligation.
Yeah, it's $400 a month.
Has she made all of her payments due under
She
this
is.
loan agreement?
She is not.
Does this loan agreement provide for any hardship exception, allowing her to miss any payments or move any payments to the end of the loan?
No, it's not.
Your Honor, requesting permission to show the witness another document.
Permission granted.
Mr. Banker, I'm pulling up on the screen a document that has been marked as Exhibit 13-2. Do you see that document?
Yes, I do.
Do you recognize it?
Yes. This appears to be the payment ledger for Mrs. Detter's loan with the bank.
How are you familiar with this document?
As the credit manager, I am regularly monitor the payment ledgers for the loans that the bank makes.
And as a credit manager, are you familiar with the bank's record-keeping practices and procedures?
Yes, I am.
Is it customary that the bank would make a record of its borrowers' payments at or near the time of receipt of such payments?
Yes, it is.
Who at the bank would be responsible for making a record of the borrower's payments?
The accounts receivable clerk who would receive the check or payment and then apply it towards the loan.
Are documents like this document before you kept in the course of the bank's regularly conducted activity?
Yes, they are.
And is making a record like this a regular practice of the bank?
Yes, it is.
Your Honor, I would move that Exhibit 13-2 be admitted into evidence.
Ms. Champion, any objection?
No, Your Honor.
All right. 13-2 will be admitted without objection.
Mr. Baker, in accordance with this document, when was the last time the debtor made a loan payment?
November of last year.
And what is the current outstanding payment arrearage owing under this loan?
$2,400.
Your Honor, requesting permission to show the witness another document.
Permission granted.
Actually, Your Honor, to back up just for 1 second, and I just would ask the witness, Mr. Baker, the only security for this loan agreement is the 2017 Toyota Camry owned by Ms. Detter, correct?
That is correct.
Do you understand that that car has been damaged?
Yes, I'm aware that it was in an accident.
And how did you learn that?
I read about it in the newspaper.
So now, Your Honor, repeating my request, may I show this witness a document that's been filed and marked?
You may.
Mr. Banker, I'm pulling up on the screen a document that's been marked as Exhibit 13-4. Do you see that document?
I do.
Is that the newspaper article that you saw?
Yes, it is.
And what does it say?
It says that Mary Detter was involved with in an accident with the mayor of Atlanta. I guess that was May 18th.
Objection, Your Honor, at least to the extent Mr. Bates seeks to enter this newspaper article into evidence. It's impermissible hearsay. There's been no indication that this is an authentic newspaper article and it's not relevant.
Mr. Bates, response?
Your Honor, I know we addressed some of these at a prior hearing, and I would submit that the newspaper article is self-authenticating with respect to that objection. The subject of this article is certainly relevant with respect to the condition of the bank's collateral. But then finally, Your Honor, I would say with respect to the hearsay objection, there's a residual exception in the rules with respect to what would otherwise be a hearsay document. If there is sufficient guarantees of trustworthiness with respect to the document, which I think there's no issue with respect to whether or not this is a true and accurate reflection of a newspaper article. And then furthermore, just with respect to the reasonable efforts and the totality of the circumstances to proffer the type of evidence that we're dealing with here, the question would be, what other way would the debtor have to present evidence with respect to the occurrence of this accident that would be reasonable under the circumstances and not unduly burdensome? So under the residual exception, we would submit that this is probative with respect to a relevant issue, and that under the totality of the circumstances, that given the reasonableness of the efforts that the bank would be forced to undertake to prove such a point, that this is an exception to the hearsay exclusion.
Ms. Champion, any response?
Well, I believe Mr. Bates said that he planned to call Mary Detter as a witness later. Certainly, he could ask her if she was involved in a car accident. He need not resort to a newspaper article that may or may not be true.
I'm going to overrule the objection and allow the document into evidence.
Thank you, Your Honor.
Thank you, Your Honor. I'm going to stop sharing my screen and request permission to show the witness another document.
Permission granted.
Mr. Banker, I'm pulling up a document that's been marked Exhibit 13-6. Do you see that document?
Yes, I do.
What is that?
That's a picture of Mrs. Detter's car after the accident.
Objection, Your Honor. There's been no foundation laid to suggest that this is Mary Detter's car. Mr. Bates has not established that this is an authentic picture or that Mr. Banker took the picture or has any personal knowledge of who took the picture to establish a foundation for admission.
Mr. Bates? Your Honor, I can certainly ask the witness a series of questions with respect to how the bank came to be in possession of a document like this.
I'm going to sustain the objection, but allow you to explore laying a proper foundation.
Thank you, Your Honor. Mr. Baker, how did you obtain a copy of this photograph?
We arranged to have somebody go take a picture of the vehicle after the accident.
So this person was hired by the bank?
Yes, yes.
And do you believe this is a picture of the bank's collateral?
Yes, it is.
Does the bank have a right to inspect its collateral?
Yes, it does.
And does the bank regularly conduct inspections of collateral and keep records in the ordinary course of the bank's business activities?
Yes, it does.
Your Honor, I would submit that this is a business record and is therefore properly admissible.
Ms. Champion, any response?
I would just stand on my prior objection. Mr. Banker did not take this photograph and cannot testify that it is in fact her car. We can't even tell if it's a Camry from the picture, let alone Mary Detter's vehicle.
I'm going to overrule the objection and allow the document.
Thank you, Your Honor. One last line of questions. May I be permitted to show the witness one last document?
You may.
Mr. Banker, do you see the document on the screen marked as 13-3?
Yes, I do.
What is that?
That's a valuation of Mary Detter's vehicle.
How did you find this information?
I conducted some online research, specifically looking at reputable sources for automobile valuations.
Your Honor, I would move that Exhibit 13-3 be admitted into evidence.
Ms. Champion, any response?
I would object to this as inadmissible hearsay. Mr. Bates hasn't established Mr. Banker's competency to testify to this document, or that he's an expert in car evaluations.
Mr. Bates?
Your Honor, we would submit that under Federal Rule of Evidence 803-17, this would be properly admissible as an exception to the hearsay rule as a market report. This is an online publication that is widely regarded as trustworthy. It is generally used by the public, and therefore it qualifies for an exception to the hearsay rule.
Do you have any case law support for that proposition, Mr. Bates, other than citing 803-17?
Your Honor, I don't have that on hand, but I'm certainly willing to submit a post-hearing brief to establish that this is properly admissible evidence.
All right, I'm going to hold determination as to whether it's admissible till the party briefs the issue following the hearing. I'm going to allow the question subject to objection for that purpose.
Thank you, Your Honor. One final question, Mr. Banker. Based on the information that's provided in this market report, what is the value of your collateral?
We believe it's about $13,200, even if there was no damage on the car.
Thank you, Your Honor. Nothing further.
All right, cross-examination, Ms. Champion.
Yes, Your Honor, just a couple of questions.
Mr. Bates, can you stop sharing your screen, please?
Yes. Thank you, Your Honor.
May I proceed, Your Honor?
You may. Thank you.
Good afternoon, Mr. Banker. I'm Ashley Champion. I'm representing Mary Detter in this case. How are you?
I'm good, thank you.
Good. You aren't the loan officer on Mary's loan, are you?
No, I'm the credit manager for the bank.
So then you don't have any personal knowledge of the loan document or what Mary Detter understood regarding the loan document, do you?
I do not know what she personally understood regarding the loan.
And you weren't personally in touch with Mary Detter about the loan, were you?
I was not.
So it's possible then, isn't it, that she could have applied for an abatement that wasn't properly processed and you wouldn't know, right?
I suppose it's possible. We generally keep on track of what abatements are applied for, but it's possible she's talked to someone else at the bank that I wasn't aware of.
Thank you, Mr. Banker. No further questions, Your Honor.
Any redirect, Mr. Bates?
No, Your Honor.
All right. You done with this witness?
We're done with this witness, Your Honor. Yes, thank you.
Any other witnesses?
We would call Mary Detter.
I don't see a Mary Detter on the screen, Mr. Bates.
Well, Your Honor, she is the debtor in this case. I would certainly have expected her to be here for this very important hearing.
Did you subpoena her, Mr. Bates?
No, Your Honor. We did not issue the debtor a subpoena in her own case, thinking through it, I believe I saw her name on a will call list of potential witnesses for this hearing, but we did not subpoena her.
Ms. Champion, was your client listed on a will call list for witnesses?
We believe that she was going to be present, Your Honor. I don't believe we put her as a will call witness. If we did, it was inadvertent. She should have been on a may call list instead of a will call list, but we did believe that she would appear.
Bear with me one second. I'm looking at the pretrial order, and there is, she is designated as a will call witness. Is she
I'm here.
available
Sorry
now?
about that.
All right. I see Ms. Detter's now here. Go ahead, Mr. Bates.
Thank you, Your Honor. Your Honor, I would know that I would have asked for permission to subpoena Ms. Detter to a future hearing if she had not appeared. But thank you very much for appearing, Ms. Detter. Ms. Detter, isn't it true that your loan agreement with First American did not contain any hardship exception?
No, that's not true. When I bought my car at the dealership back in 2020, they told me it had a hardship exception.
Your Honor, requesting permission to bring up Exhibit 13-1, the loan agreement.
Permission granted.
Ms. Detter, do you see that document on your screen?
Yes, yeah, I can. Yes.
Is that your signature on the agreement?
Yes, it is.
Ms. Detter, would you not agree that this document provides that this agreement reflects all of the terms of the agreement between you and the lender? And notwithstanding anything to the contrary, no other terms, communications, or promises with respect to this loan agreement shall control or affect any of your obligations whatsoever, no matter what someone told you at the car dealership?
Based on what I was told.
Ms. Detter, the question really is yes or no. Do you agree that this document has an integration clause?
Objection, Your Honor, and that calls for a legal conclusion.
Mr. Bates.
Your Honor, I would similarly move to strike the testimony of Ms. Detter as being non-responsive and also an attempt to introduce hearsay into the record here. What we have under the best evidence rule is we've got the actual document that is in effect in this proceeding. And Ms. Detter is trying to testify with respect to her recollection of it when we have the actual best evidence of the documentation right here in front of us.
Well, the objection was you're asking for a legal conclusion. You asked her about an integration clause. She's not a lawyer. She doesn't know what an integration clause is. So you have a right to a broad cross-examination, but you don't have to have a right to ask her for legal conclusions. So cross-examine her as best you can without asking technical legal questions, Mr. Bates.
Understood, Your Honor. Thank you. Maybe I'll just finish with a final line of questions. Ms. Detter, isn't it true that your new job is over 40 miles away from your home?
Yeah, that's correct.
And your old job was only a 5-mile commute?
That's right.
So you're actually using this automobile a lot more than you used to, causing it to depreciate much more rapidly. Isn't that correct?
Objection, Your Honor. I don't know why this line of questioning is relevant. There's nothing in the loan agreement that contemplates any sort of restriction on the use of her car.
Mr. Bates, response?
Your Honor, that may well be true. There's nothing in the loan agreement with respect to that, but it's certainly relevant to the issue at hand, which is the depreciation of the collateral of the bank. Therefore, Your Honor, I would submit that's an appropriate line of question relevant to these proceedings.
Ms. Champion, any further response?
No, Your Honor, I still don't think it's relevant, though, how her commute has changed. I can't imagine it impacts the depreciation that much.
Well, any impact makes it relevant, I think, so I'm going to overrule the objection.
Thank you, Your Honor. One final question. The use of your car for your longer commute is causing it to depreciate more rapidly than it was before. Isn't that correct, Ms. Detter?
Yeah, I guess so.
Nothing further. Thank you, Your Honor.
Redirect. Ms. Champion?
No, Your Honor.
All right. Any further witnesses, Mr. Bates?
No, Your Honor.
Any evidence you care to put on, Ms. Champion?
Nothing further from us, Your Honor.
All right. That concludes this portion of the evidentiary hearing. I'll call on the lawyers to comment first. Mr. Bates, your thoughts?
Well, sort of similar to the first scene, some of the takeaways is just having the documents ready and being facile with the technology. Even having practiced this a few times, it was just a little bit difficult to pull up the exact documents you wanted at the exact moment that you wanted. You had to sort of had to practice through the software to scroll down and find the right documents. The other thing is just about sort of the presentation style of being properly centered in the camera. I have purchased a camera that kind of drops down in the screen a little bit so I can look more directly at the screen and present. And then in terms of the evidentiary issues, I thought the subpoena issue was a very interesting one with respect to, we don't consider often having to subpoena a debtor to appear at a hearing. I'm not sure that every evidentiary hearing is going to have a will call and may call list in the classic form. And so giving some thought to making sure the people you need to examine are in attendance, I think the subpoena rule is something to consider.
Ms. Champion, your thoughts?
Yeah, I would agree with what Brian said, but also just on the flip side of that coin, if your debtor has not been subpoenaed and doesn't need to attend the hearing, maybe think about whether to have them attend and be subject to cross-examination if that's necessary for your case.
Yeah, I thought this was a good demonstration of kind of direct and cross-examination. I would like to open it up if there are questions among the participants. If anybody wants to raise a question before we conclude in the chat feature, we would love to answer any questions that we're able to. And we'll give parties a few minutes to raise any questions you would like to.
We did have one question in the chat, Judge, addressing the impeachment evidence issue. Somebody pointed out that impeachment evidence won't always be known in advance and that the attorney won't always be able to know and then provide the document in advance. Maybe just a commentary on your thoughts on changing your chamber's procedure.
Yeah, I agree with that. And it's not come up in any hearing I've had, but I have for a while thought about changing my procedures to specifically allow for impeachment or rebuttal evidence to be offered. No one's ever raised the issue, but I think it's certainly something that I've thought about and probably will make an amendment to my procedures to address because I think certainly sometimes issues come up at trial for which you would not have had an ability to submit a document in advance of a hearing, and you should, in fairness, be able to offer impeachment evidence to challenge testimony that wasn't fully anticipated. So I anticipate that I probably will modify my procedures to address that issue appropriately.
I looked at the procedures and thought about it in advance of this. And I thought there was room in the procedures for a ruling in a reasonable setting to allow impeachment evidence as may be needed. I think it's perfectly appropriate question to ask. Well, how long have you known about this? Should you have anticipated presenting this evidence? And so is this, you don't really want to open the door for too much ambush opportunity, I suppose. I thought the procedures would not have to be adjusted to account for impeachment possibilities.
I think one of the a couple of important takeaways from this last session. One, how critical it is to know how to get business records admitted and to lay the foundation for a proper business record. And another thing that took place in this session that didn't take place in the other sessions was relative to Mr. Bates asking questions of a witness about a document before the proper foundation was laid and before the document was admitted into evidence. And this is something pretty routine that happens even in a lot of cases is lawyers will ask witnesses questions about a document before it's been admitted into evidence. And frequently we get no objection to that. But I think the proper procedure is to have the document admitted before substantive questions are asked about the document. And that was corrected by Mr. Bates laying a proper foundation after the objection was raised. We don't really usually receive those kind of objections, but I think the objection was well founded. And so you should lay the foundation, get the document admitted before you ask substantive questions. Frequently, I'm asking counsel at the end of their presentation, okay, which exhibits do you want to have admitted? Because they haven't actually technically moved them into evidence. And so I think it's critical that you remember, one, to move the exhibits into evidence, and two, that there be a clear record of them being admitted. And it's the obligation of counsel presenting the evidence to make sure that happens. I see Mr. Adkins has asked a question. How would a debtor introduce something like a bank statement into evidence other than just to identify it? The debtor is not a bank officer, so it can come in as a business record. Any thoughts on that, Ms. Champion or Mr. Bates or Mr. Johnson?
Well, I would say that's like the pay stub. You're not bringing it in as a business record. You're not the bank who maybe the officer doesn't have knowledge of that exact record, but they have knowledge of how they're kept. So yeah, I think it's the debtor's record, and they can identify it and bring it in, and that's all you need.
I agree with that. Any other questions? We'll give you just a couple minutes. 1 minute, maybe. While we're waiting, I want to thank all the panelists. They put a lot of effort into making this presentation. The lawyers and the witnesses took a lot of time out of their busy schedules to make this happen, and we owe them all a debt of gratitude. So I want to thank all of them and thank all of you for participating. Hopefully you've learned. Oh, we have another question, but before I take the question, I want to say that hopefully you've learned a little bit during the presentation. So Mr. Stein says, understanding every case is different, and I'm posing this question in a vacuum. Would you give a pass to creditors' counsel for not having the debtor under subpoena and allow for a follow-up hearing? That's a question directed to me. I think it depends on the facts and circumstances of the case. I actually have had a similar scenario to what was presented in court. And I thought in my case that the party was kind of playing loose and not having the witness available. And so I made them present the witness without a subpoena. But I think it comes down to the facts and circumstances of every case, and I would take it up. But I would certainly not want to, harm a party's presentation of their case. If it was and then part of it depends on whether it was a full scheduled trial with a pretrial order where the witnesses are listed, or a more common scenario in a mass calendar, or a kind of a non-scheduled trial where there's not a full pretrial, a fulsome pretrial order, and the procedures are a little less strict. I would probably allow every benefit of the doubt to allow the evidence to be presented. Any other questions? Any other panelists have thoughts on that last question?
Well, can we quote you on that later?
No.
We all agree on that point.
All right. Thank you all very much for attending. Hopefully it was of some benefit to you. We very much appreciate you attending.
Thank you. It's been
Court's
fun.
in recess.
Thank you, everybody. Be on the lookout for information about the next Lunch and Learn presentation. And thank you to all of the panelists and attendees. Thank you for all of your hard work and a great presentation. That will adjourn.